Pacer Center's National Parent Center on Transition and Employment presents Workplace Accommodations. Our presenter today is Ann Robertson, who is a staff attorney at the Minnesota Disability Law Center. Does the ADA, or Americans with Disabilities Act, protect accommodations in the workplace?
For civil rights laws for employment with persons with disabilities, we focus on the Americans with Disabilities Act, or the ADA. That's the federal law that governs employment of persons with disabilities. We have a state law as well, the Minnesota Human Rights Act. So the ADA prohibits discrimination in employment in a lot of different ways. And when people with disabilities are treated differently than people without disabilities, and we can prove it, that kind of discrimination is called disparate treatment or different treatment. The first thing you got to prove under the ADA is that it applies to a qualified person with a disability. That is somebody with a disability, typically somebody who has a diagnosis from a medical provider who, with or without a reasonable accommodation, can perform the essential functions of the employment person. So some position that they're seeking. So somebody who's qualified for that job and meets the qualifications necessary to do that job. Some of the language of the ADA include not making reasonable accommodations. It's discrimination to not make reasonable accommodations to the known physical or mental limitations of an employee with a disability.
What is a reasonable accommodation, and what are some examples?
I encourage everyone, as you think about reasonable accommodation, really focus on the word reasonable. That's very important when trying to enforce it, when asking for it. When proving to a judge you meet the criteria for a reasonable accommodation. So a reasonable accommodation in employment is any modification or adjustment to a job or a change in a job, either the job, the work environment, or the way things are done that enables a qualified individual with a disability to enjoy equal employment opportunity. So what we're talking about is leveling the playing field in the workplace. We're not treating people the same. We're not proving that somebody was treated differently because they had a disability. We are trying to remove a barrier for a person with disabilities in the workplace. So some examples of reasonable accommodation employment that are commonly thought of and have been enforced in the courts as reasonable accommodations in employment. Changing or modifying policies or practices, reassigning marginal job functions. These are job functions that aren't the main thing that somebody is doing in their job. Somebody going to a part-time or a modified work schedule, like working later or earlier in the day, if that works out if that's possible in the workplace. Taking a leave, either paid or unpaid. Or a reassignment to an open or different position or lower position, typically, if it doesn't violate a collective bargaining agreement or if there's no other reasonable accommodation. One possible reasonable accommodation could be allowing more time for training or orientation. A lot of transition-aged youth, they haven't had a job before. They're new to the workplace and they might need some more time because of their disability to get up to speed. Another possible reasonable accommodation for transition-aged youth could be allowing communication about job performance or training needs with a job coach or a vocational rehabilitation counselor. A third example of reasonable accommodation employment for transition-age youth could be, time off for medical appointments. Typically, students or transition-age youth have high medical needs. They probably have more medical appointments that they need to attend, and that's going to be something that will likely interfere with work or work hours, and that's something that you would have a good chance of getting a reasonable accommodation for.
How do I request them, and what does the process look like?
The request should be in writing. It will go better if an employee mentions that what they're asking for is a reasonable accommodation. Employees don't have to identify the disability if it's not obvious. At the same time, they need to show the connection, the direct connection between the disability and the need for the accommodation. Someone requests the reasonable accommodation, hopefully in writing, and you keep a copy of it so that you keep kind of tabs on what the process is and what has happened at various times. You go through what they call an interactive process. And this means that the employer, supervisors, managers, and human resources staff, they need to recognize reasonable accommodation requests. And it has to be in a timely manner. The parties need to engage, and the law envisions that the parties engage in an informal interactive process where the employee asks for a reasonable accommodation, the employer considers it, may come back with, well, we can't accommodate that, but we can change a policy in another way so that it meets your needs. It may not be your preference, but it enables someone to continue working. An employer under the law may ask for medical documentation if the disability isn't obvious or the need for the accommodation isn't obvious. That, again, that doesn't mean that they need diagnosis. They don't need excessive information, but they do need they need to provide some information about what the disability is, what the reasonable accommodation is, and that I like to see the phrase medically necessary. So, one thing to keep in mind is if your medical doctor or medical provider doesn't support what you're asking for, it's probably not a good idea to pursue that sort of reasonable accommodation. You really need to have your ducks kind of lined up in a row before you go asking for a reasonable accommodation.
Can an accommodation be denied?
If it results in an undue hardship, if it costs too much, or it's too extensive, or too disruptive of the workplace, they don't need to provide an accommodation if providing that accommodation poses a direct threat to health or safety of that employee or others in the workplace, or if it results in what they call a fundamental alteration of the position or business. If it so changes how the workplace works, that it's a fundamental alteration. So when courts take a look at that, they focus on different aspects of the employer. What kind of resources? Is it a big company? Is it a little company? If someone needs to come into work late for some reason, is it in the airline industry where being on time is super, super important? Or is it in a business where it doesn't matter that much? And the judge will take a look at all of this and weigh them. We'll take a look at the costs and the benefits, the pros and the cons, and we'll weigh that in making a decision. And that's kind of where the reasonableness comes into play.
Thank you for watching. For more resources from the National Parent Center on Transition and Employment, please visit pacer.org. And a special thanks to Ann Robertson from the Minnesota Disability Law Center.